So whenever a startup founder approaches me during their fundraising transaction or even at the negotiation stage, and they tell me that the investor is asking for a board seat in their company, I have to actually ask them, what does a board seat even mean? Because legally, it's not a defined concept anywhere in the Companies Act. But in the commercial sense, it can mean either of the two things. But you need to have clarity as a founder, what is the investor looking for? Now, the first thing that it can mean is that the investor is looking for a director role in your company. Now, if that is the case, and if you are giving them the director role, what you have to understand, first of all, is that you have to do the statutory filings. It's not only a contractual right, you have to keep MCA aware of it, and you have to make them a director through a process. And once that is done, then yes, they have legal duties towards the company, but they will also have rights, especially they will have a say and a voting right in your operations, day-to-day operations. So you have to understand whether you want to give it or not, and is it feasible for you or not. The second thing that it can mean is that they are asking for observer or nominee rights in that sense, which essentially would not give them voting rights in the operations, but would give them information rights. So they will have access to your board meetings, to your board resolutions, and they will know what is happening in the company, but they will not have voting rights. So these are two different things altogether, and combining both of them under the umbrella of a board seat is sometimes misleading. However, this is how commercially it happens. But you as a founder, once you are executing legal agreements, you should be very well aware of what the investor is looking for and what is the legal consequence of it, not just commercial aspect.